Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is number 2023-1540, GEICO versus Glasco.
May it please the court. I'm John Marino, and I'm appearing this morning with my partners Lindseay, Trout, and Max Gerson, and we represent GEICO. Could I reserve 5 minutes for rebuttal, please? The Florida Motor Vehicle Repair Act uses the word customer 65 times. The word customer is a defined term under the Act. It's defined as the person who signs the written repair estimate or any other person whom the person who signs the written repair estimate designates on the written repair estimate as the person who may authorize repair work. So the legislature presumed two things in defining the term customer under the Act. One, that there would in fact be a written repair estimate, and two, that somebody would be signing that estimate. So this case deals with what to do when a windshield repair shop doesn't give an estimate to anybody, so nobody can sign one, as well as commits additional violations of the Act. The 11th Circuit has asked this court to answer two certified questions in these circumstances. Turning to the first question, which is, can GEICO bring a direct claim under the Act in these circumstances? Section 921(1) of the Repair Act gives a private right of action to any customer who is damaged by a violation of the Act. So Glasco just doesn't give an estimate to anybody, so nobody can sign one, and then there's no customer. That simply.
Well, let me ask you something about this estimate. Doesn't the basic provision here say that when the customer requests a motor vehicle repair shop to perform repair work on a motor vehicle, the cost of which repair work will exceed $100 to the customer? That's the kind of the operative language. That's what gets us off going down the pathway. Am I wrong?
No, that's correct, Your Honor.
Well, and isn't in the case in these circumstances that the customer, just given the way that the insurance law is set up and the requirements that there be no deductible under these comprehensive policies, that the customer is going to pay nothing.
The customer is going to pay no deductible, Your Honor.
Well, pay nothing, right?
No deductible.
So there's no way that it's going to exceed $100 to the customer.
Well, that's not correct in this case, Your Honor. In this case, if you actually look at the assignment of benefits that they have these insureds sign, it specifically states, I further understand and agree that if my insurance company should ignore this directive to pay or otherwise fails to pay Glasco, Inc., all amounts due hereafter, I will directly pay Glasco, Inc.
So your position here is dependent upon an assumption that you are going to violate the law.
No, sir, Your Honor.
Your client's going to violate the law.
Well, not my client, no.
But, by not paying, but the insurer by not paying what the insurer is required to pay.
Your Honor, I mean, insurance is not limitless. There are limits on insurance. It's true there's no deductible, but there are limits on insurance. And, they're not telling the insureds how much they're on the hook for. Because the assignment of benefits, and that's at docket 20, page 548 of the record, it specifically says they're keeping them on the hook for all amounts due hereafter, but they're not telling them how much those amounts due hereafter may be. I mean, their amounts, they're chasing GEICO now, but they haven't recovered everything they want to recover on these invoices that they've sent.
So what would GEICO do if the customer decided that they wanted to just pay the invoice and then submit a claim to GEICO? Would GEICO kind of interrogate the customer to say, well, were you actually legally required to pay this? And if the answer is no, because the notice wasn't given, would GEICO then deny the claim?
Your Honor, if they submitted a claim, then GEICO would pay to the limits of its liability.
Regardless of whether,
Well, no.
regardless of if the customer, let's assume that the statute wasn't complied with by
Sure.
Glasgow, what would GEICO do? And would they say, well, you didn't actually owe that, so we're not paying it?
I believe that's correct, Your Honor. If it came to GEICO's attention that in fact the statute wasn't complied with, they didn't give the appropriate notices. They didn't give the estimate that's required. They didn't send an invoice. They're claiming that the customer is the insured. They didn't send an invoice to the insured. They gave them no notice at all. I mean, the statute's designed for transparency. That's what the whole statute centers around. But yes, Your Honor, we would not pay, or GEICO would not be obligated to pay under the law if they knew that the services basically weren't lawful in the first instance.
So
Well, it's just hard, but again, a predicate here is injury to the customer. And I'm just struggling to see any injury that you can raise or that a customer would want to raise. There are no customer complaints about any of this. It's the insurer's complaint. It appears from what's been happening in the lower courts that the insurer decided they were going to lowball on these claims. They were going to pay less than the amount that was invoiced. And am I wrong in reaching the conclusion that every court that has considered whether the insurer paid enough when there was a dispute about it has decided that the insurer was not entitled to pay less, the lesser amount that they'd paid?
We've actually won some trials in the county courts, Your Honor. So not every court has made that determination. Only one case has actually gone to jury trial, and the jury verdict came back for GEICO in that situation. Went on appeal. Well, the judge overturned the verdict, went on appeal, and the second DCA just reinstated the verdict. So you're right, Your Honor. We're losing the great majority of the cases, but we're winning some, and we won a jury trial. But the other point is, Your Honor, these cases aren't considering the Repair Act. In the county courts, they don't hear the Repair Act at all. They either strike their affirmative defense if you raise it, or they grant summary judgment. So nobody hears about the Repair Act. We weren't even allowed to raise the Repair Act in the case we tried to a jury.
Well, so you think that's been improperly stricken?
I do.
That's subject to appeal?
Well, some of them are on appeal now, Your Honor, and that's been stayed. There are, I don't know how many appeals, there's several appeals before the second DCA. They've stayed those cases pending this court's determination.
I guess my problem is more fundamental. Can we talk about just the text? I don't see a private right of action to anyone but a customer in the statute. And I don't see how GEICO is a customer. Help me understand those brute realities of the text.
Well, remember, Your Honor, the customer is a defined term.
Yes.
And it's fact specific.
Well,
right?
I don't think
it's who signs.
Is GEICO's position, has GEICO's position ever been, and is it here today, that it is a customer?
I think under these circumstances, we should be considered
Under
a customer.
which circumstances?
The circumstances where the statute wasn't complied with. Because remember, we have no customer.
Okay.
Nobody signed a written
So
repair.
your argument is whenever the cause of action only lies when the statute hasn't been complied with. It is a cause of action for violations of the statute.
Correct.
Okay. So your argument sort of consumes itself beginning with its own tail. The cause of action only exists when there's been a violation of the statute, and those are the circumstances you're saying where we should ignore the word customer and just substitute payor for customer. Unfortunately, that's not what the text says, and your briefing, if I may say so, doesn't really square up to just the brute reality of the text. It instead asks us to consider legislative intent. It asks us to consider all sorts of phantasmagorical considerations about what might be lurking behind the text. But I have not seen GEICO square up to the actual words of the statute and say, we are a customer or we are not, and I'm giving you an opportunity to do that here.
We should be considered a customer in these circumstances because there's not a
In the circumstances wherever there is a cause of action.
Not just wherever there is a cause of action, but under these circumstances where no customer exists, because the insured's not a customer either. Nobody's a customer under the plain text of the statute, because the customer is the person who signs the written repair estimate or their designee. So who were their designees?
So if it's not covered by the statute, we just make it up?
No, I'm not asking you to make it up, Your Honor.
Well, I think you are. It's hard for me to see how what you're doing is anything other than asking us to fill in some gap that is not covered by the statute. I mean, I don't understand how to decode your argument in any other way. And have you read our cases recently when we talk about the supremacy of the text? Your briefing doesn't seem to indicate that.
We have read the cases, Your Honor, and supremacy of the text. We realize you start with supremacy of the text, but you don't take it to the degree where the statute becomes meaningless.
I think the issue with your interpretive argument, you've presented this entire argument in the 11th Circuit and here is a matter of interpretation. And it sounds like what you're saying is like there's a right without a remedy, and people make those arguments, but it's not a matter of interpretation. That's a completely different challenge that's based on the constitutionality of a statute. And so why should we contort a statutory analysis to fit an argument that you haven't made?
Well, Your Honor, you know, the district court actually called this a hole in the statute, and they went beyond the plain text. They construed it narrowly, and they decided that in these circumstances, they basically filled in a customer, right? They said it can only be the insured. I don't think that's correct, but that's what the district court did. The district court recognized that, you know, if we reach the conclusion that we have no customer, then we have no repair act.
Go on. It seems odd that you're saying that the role of this court is to fill in holes in statutes rather than interpret text as it's written.
Well, I think you do interpret text as it's written, but you don't take that to the extreme that there's in fact no statute. You basically written off the statute.
So your argument kind of turns on the absurdity doctrine.
It does. Well, the absurdity doctrine, yes, and ambiguity, because it's not the definition of customer that makes this statute ambiguous. It's the lack of any guidance of what happens when they violate the Repair Act. There is no written estimate, so you don't have a customer, and the statute doesn't tell us what to do in those circumstances, and that's what the district court did.
It would seem to me, though, to sort of build on what this colloquy with Justice Sasso you're having. It sounds like these are great arguments for across the street. I don't understand why you're making these arguments here. If there's a hole in the statute and you say that this is some sort of like a null set where there is no customer in this weird circumstance of windshield repair because of the way the market has played itself out, sounds like you've got a legislative issue. Don't you agree?
It is a
Hire
legislative
lobbyists.
issue.
Go
Your
across
Honor,
the street.
It is a legislative issue, and the legislature has actually dealt with these issues going forward. The legislature recently took away the assignment of benefits. So they basically cut the glass industry off at the knees. They took away the assignment of benefits, I think it was as of May of 2023. So they recognized the issue, and they dealt with it going forward. But there's still some backlog here with the cases that are still pending. And basically, what we'd be doing is allowing unlawful services to be compensated.
Let me ask you about that, because that seems like, to me, that's an easier sort of textual argument that also I think is a problem for you, which is, it seems like all this law sort of goes back to this Osteen case from '86.
Correct.
Where it was just kind of assumed that where the notice requirements aren't complied with, that essentially that the customer owes nothing. Mm-hmm. And that's definitely, I don't see that indicated in the text. You know, the civil remedy talks about where the customer is injured. We now have the sub 7 that's been added that basically instructs the enforcing government authority that where in fact the customer, you know, was on notice of what was going on and a legitimate service was provided, the company gets credit for that. So if we think that whole premise is wrong, that you know, that the customer owes nothing in those circumstances, what does that do to your case? I mean, I think for question number 2,
correct,
it would basically, you'd lose on that, right?
If that was your decision, yes.
Yeah, and so, but I don't want to put words in your mouth. I mean, what's your take on that?
I think two issues, Your Honor. One, the statute, it doesn't contain an express voiding penalty. It doesn't say you can't get paid if this happens, but it does say you can't start work until you've satisfied the requirement to give the written disclosure and to give the estimate. The statute
but we're still just back at the same point of if the statute isn't complied with, what's the remedy? It seems like what the remedial part of the statute says is if the customer can prove that they were injured by it, then, they get whatever the remedies are. But it just seems like this whole area has been premised on just kind of a mistake at the beginning back in Osteen.
Well, I don't know that I characterize that as a mistake. I mean, every court that's considered the issue has said, starting with Osteen.
Essentially just citing that Osteen itself, you have to admit, there's no reasoning in there. It just kind of assumes that that's the remedy.
It says it's a remedial statute, and to effectuate its purposes, we're not going to allow payment. And that's what the line of cases have followed. But the legislature is deemed to be aware of the interpretations of the statute. And like Your Honor pointed out, they amended the statute to add Section 921.7, right? Section 921.7 is an exception, like Your Honor said. Under Section 921.7 of the statute, you can get paid under limited circumstances. 4 things. 1, the work was actually approved. 2, the cost was actually approved, orally or in writing. 3, the customer benefited. And 4, the work was done satisfactorily. So why would the legislature put in an exception to allow payment under certain circumstances if the legislature intended that you couldn't get paid, if the legislature intended that you could get paid even if you violated the statute? Why would the legislature put in an exception under those circumstances?
Well, why would the legislature say you have to be injured? So how do you explain that?
I think GEICO is injured. They've been sent bills for things that are not payable under the Repair Act.
Well, how was the insured injured?
The insured is injured because they're still on the hook, as I said, for amounts that were never disclosed to them. Who knows what would have happened, Your Honor, if they said, here's a written estimate, here's what we're going to charge you. I mean, that's what the Act is designed for, right? Transparency. So who knows what would have happened if they said, we're going to charge you $1,000 for this windshield. Well, maybe the insured says, well, that sounds like a lot for a windshield, and I'm not sure my policy covers that amount. Maybe I'll call up my insurance company and see whether this will be covered. Or maybe I don't want to make a claim that large against my insurance policy, so I'm going to go down the road and see whether I can get it for less.
I mean, the problem, though, is that, this is a prophylactic statute. If every single piece of material information was disclosed orally, and there was a complete knowledge by the customer and they could go through all this thought process that you're talking about, there would still be a violation and you would still be saying that the customer owes nothing and therefore you owe nothing.
Well, if it had been disclosed orally, it may be subject to the quantum merit exception that the legislature wrote in.
But in some ways, all of these factual things sort of it kind of confirms the wisdom of why it really does need to be the customer. You either need to be standing in the shoes of the customer,
and I think we are,
which you've throughout this entire litigation you haven't. You've said we have no subrogation, whatever. So this is you guys coming in on your own.
Well, I think we should.
So you're basically trying to assert all these things that really only the customer is in a position to assert.
But it still comes back, Your Honor, to under these facts, there is no customer, and the courts are just assuming, it must be the insurer.
I don't know that
nobody signed a written repair.
I don't know that we need to agree that defined term, obviously in the notice context it makes sense, but there's all kinds of stuff in here that says, you can't put a false thing on the credit card or whatever. I think if the Department of Agriculture and Consumer Services wanted to, go after a company for doing that, I don't know that the company would be able to say, well, actually that doesn't protect a customer, or it only protects someone who signed, there's no sign, so therefore you can put these charges on some. I think it's arguable whether we need to be that literal about the defined term, but it still doesn't get you to be the customer.
If that's what the court's going to determine, I still believe we should be able to assert an affirmative defense. You're right, Your Honor, we haven't raised subrogation. That's not on the table. But that doesn't mean we don't stand in the shoes of our insured. Because if our insured doesn't owe anything, then how does GEICO owe anything? I mean, if I have an insurance policy and I don't owe anything under the insurance policy, my insurer doesn't have to pay.
So if we disagree with you on the premise that the customer wouldn't owe anything absent injury, then we can just answer, I guess, no to both of these questions and be done with it.
Well, I don't believe you should answer no to these questions.
But we
and be
could.
done with it.
I mean, that would be the correct. That would be the correct answer. If the premise is that it's essentially your remedy is you have to show an injury and et cetera, then at least the answer to question 2 would be no.
If you have to show if you have to be a customer and you're saying we're not a customer, then the answer to question 1
Well, even
would
if
be
you
no.
were a customer, the question I think assumes that it's just sort of per se. If I show these 5 specific violations and a claim is submitted, whether it's by a customer or by the insurance company, or whoever, the invoice is sent either to a customer or to the insurance company, that essentially whoever the receiving entity is, they owe nothing. That's your argument, right? Is that once you show that that the notice wasn't complied with?
It is. Once there are material violations of the Repair Act, there's nothing owed under the law. The law doesn't permit this work to be done before there's a written estimate and before the written disclosure is satisfied. The law doesn't permit it.
Okay, you can take 30 seconds and then we'll give you 3 minutes of rebuttal.
Okay. Well, I'll just sit for my rebuttal time.
Good morning, Your Honor. May it please the court, counsel. I'm Michael Lorado. I represent the appellees in this particular case. As the court has indicated, GEICO's purposivistic interpretation of this statute is to be completely rejected based on this court's precedent. The questions certified by the 11th Circuit are easily answerable by turning straight to the plain language of the text, and the plain language of this text, taken as a whole, will the words enacted by the legislature tell us what the legislature's intent was. We have to focus on those words, and that requires that this court answer both of these certified questions in the negative. Let me start first with whether GEICO is a customer.
What if we agree with you that GEICO is not, but that there is no customer for the purposes of the statute in this fact pattern?
I don't think you can do that reading the text of this particular statute. Because
help me understand how that's true if nobody signs a work order.
Well, because the statute in and of itself contemplates circumstances by its plain text where a customer is not to sign a written estimate. So there are circumstances by its plain text, as Justice Kennedy mentioned, that in Section 559.905, a written estimate signed by the customer with the required disclosures is only required when there will be charges to the customer in excess of $100.
That's right, but now let's answer the argument that your opponent makes, which is, of course, those charges are there. They're perhaps baked into what they're paying for comprehensive coverage, and just because they're not presented with a deductible doesn't mean there isn't a charge. There is a charge, and the customer just may not have transparency into what it is you're seeking on the back end. You're not arguing that there's no charge, right? Glasgow gets paid.
Right. I think, correct. I think that goes to the second question, right, of whether there's a voiding penalty or whether the customer would still be on the hook. Okay? So the answer to that question is, again, in the Repair Act itself, right? The language of the Repair Act is clear. If, in this case, it's undisputed that there was a written estimate which was signed that said zero to the customer, and the customer also waived the right to a written estimate. So let's assume that then Glasgow goes and submits a bill to GEICO, GEICO doesn't pay it, and Glasgow then pursues, asserts a lien, doesn't return the car, that hasn't happened here in this case, or sues on the repair invoice. The customer then would be able to say under 559.905, I didn't get the right estimate. I was estimated at zero charges. You are now wanting to charge me $1,000. The penalty provided by the statute is not a voiding penalty. The penalty provided specifically in 559.909 says that where the customer doesn't obtain this written estimate, where the repair shop doesn't do it, their liability is limited to $10 or 10%, not to exceed $50. So even in the case where a customer were not to get a written estimate, the penalty provided by the plain text of the Repair Act is to limit the repair shop's charges to $50. So the question becomes, that's the statutory penalty when a repair shop doesn't comply with a written estimate to the customer.
Wouldn't you then be arguing waiver, though? Wouldn't you be saying to the customer you waived your rights here?
Under the facts of this particular case, right? Under the facts of this particular case, the customer has to do that waiver in writing, and I believe that as a matter of record, the actual invoices, and again, the plain language of the Repair Act, permits a customer to waive the written estimate in writing. And I believe that all the written zero to the customer written estimates in this particular case also contain a written waiver of a written estimate by the customer. So the customer is not only saying, look, you can repair my car, you can bill GEICO, you're going to charge me nothing. I waive a written estimate under the particular statute. And
but what would you guys charge in the scenario where, for whatever reason, the insurance company didn't pay, and you pull out the assignment of benefits thing, and it says that the customer is still on the hook? I mean, what would you charge them? You wouldn't charge them $50, would you?
They would be limited by law to that.
No, but what would you say that what bill, wouldn't you send them the same bill that you sent the insurance company?
Correct, assuming that GEICO denied the claim,
right,
and didn't pay it. The customer would get the same exact bill that.
So it seems like, I mean, your position, the more kind of weird the more kind of absurd, I hate the word absurd and the absurdity canon and all that, but the more kind of irrational you make the statutory scheme sound by getting in all these kind of counterfactual hypotheticals. I mean, what's your position on this whole Osteen thing, and whether at the end of the day that is the problem? Because it seems like it really would be an irrational statute in a crazy world if under the same fact pattern, if Glasgow sends a bill to the customer owes nothing, and if they send the exact same bill to the insurance company has to pay 100% of the bill. Like no legislature with any foresight would ever make that the rule. Do you agree with me on that?
I do agree with you on that. I don't agree with you with this case. This case presents to us in a procedural posture where we are assuming, based on the 11th Circuit certified questions, that there are in fact violations. As a matter of record, though.
No, but let's just take the case as we found it. You know, it's limited to these 5, violations, and they've essentially teed up. It's almost like an advisory opinion type thing. You know, assuming the violations have been, that's what's on the table. Under all this DCA precedent, those violations would be enough for the customer to owe nothing, right?
Incorrect.
Okay, why is that incorrect?
Well, first of all, the statute which you mentioned, 559.920 Section 7.
Right, none of which the DCA precedent considers. That's what I'm saying. I think the DCA precedent is all wrong, but so just accept the question was under the DCA precedent.
There's Lieberman's and KT Cars.
Which says what?
Yeah, Lieberman's the first case. The repair shop prepared no written estimate at all, and instead relied on an estimate which the insurance company was going to pay. So as it related to the customer, the Lieberman's is important for 2 points, because it establishes that the distinction between the insurer and the customer. So in Lieberman's, there was no repair estimate at all, so a complete violation as it relates to the customer. The insurer had separately prepared an estimate that it was going to pay. The customer attempted to collect, I guess, the insurance benefits that were owed to the repair shop for the repair and asserted that I didn't get a written estimate, and so therefore I can keep the insurance money that was paid. So there, Lieberman said that there was substantial compliance with the statute because the customer understood the transaction, the customer understood what was happening, understood that the insurer would pay, and therefore the repair shop in that case could enforce its lien and repair and recover on its lien in quantum merit. That's the first case that says where a repair shop is kind of where the customer kind of understands the transaction, approves it, agrees to it, even if there is no technical compliance or no written estimate at all, that the repair shop can still recover on their invoice. The second case is KT Cars. The KT Cars case, there was a handwritten note. So there was some written estimate. It was incomplete and it was very basic. It certainly didn't comply with all the elements that are required by the repair shop. There again, the court allowed the repair shop to again enforce its lien in quantum merit and therefore recover even in the face of violations on its lien. So that's an important distinction in this case, right? Because there's two sections. There's the lien provisions of this statute and there's the remedy provisions, as you've said. So under the lien provisions, a repair shop is specifically, under the plain text of the statute, entitled to enforce its lien if it's in substantial compliance. So that's text-based evidence as it relates to the lien statute that there is no voiding penalty in this statute because even as it relates to a lien, they can enforce it, and the cases hold that you can enforce it in the event of substantial compliance. Here the legislature used the term substantial compliance. That doesn't mean technical compliance. That doesn't mean anything like that. And I would even suggest that Osteen falls in line with that. Because the important considerations under the statute is that the customer understood what was going on, received a beneficial repair, knew and approved of it, and when that happens, both the statute and the case authority clearly say that the repair shop should be able to recover. In terms of whether GEICO is a customer or not, the first question, again, the text is very clear. The legislature has defined customer to mean certain things, and GEICO clearly is not. I would note that they have admitted both before the 11th Circuit and in their briefs that they are not a customer as it's defined.
What do you make of their argument that you're not a repair shop?
We are a licensed repair shop, and that's all, a licensed and registered repair shop. And if you read the plain text of the Repair Act itself, we certainly qualify as what would be the definition of a repair shop. Their argument that Glasco is not a repair shop hinges on their flawed argument, again, misreading the...
Well, it hinges on your business model a little bit in that you're using independent contractors who may in turn qualify as repair shops under the statute. Their argument, as I understand it, is more that you're like a broker.
Understood that that's their argument. Here, as it relates to interpretation of this particular statute, the statute doesn't have a blanket prohibition against the use of subcontractors, and it has no prohibition against the use of independent contractors. I don't believe that's really an issue here in this particular case because it's not developed on the record about whether independent contractors or subcontractors, as that term is meant under this particular statute. But even assuming it is, even assuming that independent contractors and subcontractors are the same under the statutory language for purposes of my argument here today. So we assume that. There is no blanket prohibition of a repair shop using either an independent contractor or a subcontractor, and the plain text of the statute permits it as long as the customer knows about it and approves of it. Here on this record, in this case, in every one of these with the initial paperwork they got, there was, as reported in the 11th Circuit opinion, every customer received a document that says, I authorize sublet work to be done here. And so it's not a violation of the Repair Act. And again, I understand that I come to this case in the posture where we are assuming, for purposes of this question, that there were violations. But on the record, there really weren't violations. For instance, a subcontractor violation can only occur if the insured did not have notice of it. But yet, as the 11th Circuit noted in its opinion, every insured in its initial paperwork specifically authorized the use of sublet work. So, therefore, subcontractors. And so that wouldn't be a violation. It is conceded in terms of violation that the initial paperwork, the zero to the customer paperwork, which was signed, didn't have an odometer reading on it. But again, I think that turns back to the requirement that even if GEICO is the customer, there would have to be, in order for there to be a standalone cause of action, there would have to be an injury resulting from that. That also, the statute is plain. It's a customer who's injured by a violation of this part. Another important point, Justice, on the independent subcontractor issue. There is nothing in this record that any customer or GEICO itself was injured by the difference in the work that was performed by either, if it was performed by a Glasco W-2 employer, W-2 employee, or an independent contractor. What would be the difference in price? What was the difference in the quality of work? There's nothing. In fact, on this particular record, all the repairs were satisfactorily performed. And so what GEICO is attempting to do is kind of turn this statute on its head by its interpretation, right? All of the customers were satisfied, all of the work was satisfactorily performed, and yet it doesn't want to pay. That would be against Section 7, right? And in essence, GEICO wants to call itself not only a customer, but it wants to call itself the enforcing authority, right?
I mean, the whole thing, though, the legislature created a moral hazard by giving people the impression that this is quote-unquote free. The whole logic of the statute is that it's going to matter to people what things cost, and there may be a negotiation, et cetera, et cetera. We're applying it in a situation that doesn't really fit sort of all the prophylactic stuff and everything that's going on. I mean, even the fact that that there's a limit on the charges that's kind of embedded in the notice thing. I mean, that is a problem with the statute, that you don't, essentially when you don't do these disclosures, then there's no cap on, the $50 or 10% thing or whatever goes away, right?
Correct. I would say that that's again a legislative.
I mean, that's not our problem,
right?
But
It's not this court's problem and not this court's issue, and that's probably the most important part of this particular case. Is this is really an insurance claim transaction which is regulated by other statutes, right? Not a Repair Act transaction. I mean, I would understand here if GEICO owned the vehicle and GEICO requested it, but ultimately this is an insurance claims transaction which is governed by another policy of insurance and governed by the insurance code. And the legislature kind of knew that, right? And we know that they knew that. As it relates to your Osteen case, I think the legislature reacted to Osteen in 1993 when it added that particular section.
yeah. The DCAs didn't notice, apparently.
Right. Well, all the cases are, Osteen, Safari, Perez-Perigo, all those cases cited by GEICO 1616.
The lien cases, I grant you, but people are continuing to rely on when it's just when you're outside the lien context, and it's just a pure issue of does the customer owe anything, it seems like they still believe, or they do believe, that the customer owes nothing. And that's why I think the 11th Circuit considers this a tough case. If it weren't for that anomaly, I don't know that we would be getting a certified question, and that because it really doesn't make sense. Yeah. But the answer to that is to say that premise is wrong, I think. But
I think that all the questions presented here can be answered clearly by turning to the plain text. The definition of customer is plainly defined. It's referred to throughout the text. GEICO doesn't qualify for that. There's no basis to go into intent or anything like that. The statute even understands that there will be circumstances where an insurance company will pay. It specifically says that, but it still doesn't equate them with the customer. plain language. There was, again, the 2023 amendments addressing these issues, which this kind of a crisis which is raised in their brief, or the issues which GEICO alleges, and yet the legislature still didn't change the definition of customer. Knowing everything that was going on, they instead chose to change certain insurance statutes. They repealed 627.428, the attorney's fee statute, and they added a provision in the assignments that prohibits assignments for these type of insurance claims. But yet they didn't change the Florida Motor Vehicle Act. That simply tells us that this Florida Motor Vehicle Act doesn't apply to insurance companies, and insurance companies are not customers contemplated. As for the voiding penalty, we begin and end with the plain text there. There is no voiding penalty expressly on the text. End of analysis. The legislature, in various instances, knows exactly how to penalize someone who is non-compliant with a regulatory statute. They did it in the healthcare context, they did it in the PIP context, they did it in various other contexts, and they said that if you violate this statute and you submit a bill to an insurance company, that is non-compensable, voidable, and various other language. And so the legislature didn't do that here. This court's precedent says that the legislature, if it doesn't say that, there is no voiding penalty. Again, we can turn to the clear language of the statute. Again, I've referenced other provisions of this statute where, even where there is a violation, throughout various provisions of this statute, it's not that the repair shop recovers nothing. The repair shop may be awarded reasonable repairs. They can still get $50 from the customer. That's not a voiding penalty, and it can't be reconciled with the idea. And then even in enforcement of the lien provisions, the legislature has intended that if there is a violation of the Repair Act, but yet substantial compliance, as we see in Lieberman's and KT cars, even the repair shop can still enforce the lien, which is an entirely different remedy there.
Sir, you can finish up.
Great. Thank you, Your Honor. We would request, the plain text requires that these two certified questions be answered in the negative. Thank you.
Just a couple of points. The written waiver, there is no written waiver on these work orders. If you look at it's at docket 20, page 546, it does not have the language that counsel was referring to that says check a box and you waive the estimate. It's not on the work orders. That language appears nowhere in the record. Lieberman and KT Carr, as my friend stated, found substantial compliance. One case, there was a handwritten note, had the cost on it, customer agreed, they signed off on it, and the court said, okay, substantial compliance. The other case, the insured actually took an estimate prepared by his insurance company to the body shop, and the body shop agreed to make the repairs based on that estimate. That court said substantial compliance. In this case, the cost was never disclosed. There was no substantial compliance in this case. Those two cases don't change the rulings of the prior cases that basically say you can't recover if there's a Repair Act violation. As to Section 909, Section 909 doesn't say okay, you can get paid a little bit. It says it shall be unlawful for a motor vehicle repair shop to charge more than the written estimate plus $10 or 10%. It says it's unlawful. It doesn't allow payment when there's been no written estimate. It says it's unlawful to charge more than that. And what did they do? They charged far more than zero. Because if their written estimate is zero, they violated the law. Because that section says it shall be unlawful. Section 909.3. So, this isn't a situation where they charged $10 more than zero. They charged, I don't know what it is, $800, $900. They charged a lot more than zero and a lot more than $10. Section 559, 559.909.3 says that is unlawful. How can they recover for unlawful charges? Because that's what they're saying. They're saying, well, this work order is kind of the estimate, has zero on it. Well, if it has zero on it, they can't recover more than $10. It's unlawful to bill more than $10. And that's what they're doing. It's an unlawful charge under the Repair Act.